Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you and good morning. I want to start first by welcoming the class that's here to visit us today and to listen to the arguments. I hope that you have an enjoyable experience. We have a class here from Buckingham Brown and Nichols School. Welcome. Now I'll introduce the panel to you. To my right is Justice Joseph Ditkoff. To my left is Justice Andrew D'Angelo, and my name is Ariane Vuono. We're going to start today with case number 4 because you were all here promptly and you're ready to go. This case is impounded, as the parties know. Just for a little housekeeping, I want to remind everybody and inform the students that each side has 15 minutes to present their oral argument. We have reviewed everything that they've given to us beforehand, so often the the attorneys will go right to their most salient points and not give a lot of background information, which is perfectly all right. There is no rebuttal in the appeals court, so once one side makes their argument, they will then rest on their briefs. None of those arguments are waived, but there is no rebuttal, so they can't respond. With that said, the first case is Department of Children and Families versus Mother and Another, 2025-0803. Good morning.
Good morning, members of the panel, and may it please the court. My name is Laura Smith on behalf of Appellant Mother, who is viewing this proceeding via stream.
Okay, and before you go any further, I understand that you want to waive argument number 1.
Yes, Your Honor.
All right, so it'll be deemed waived.
Thank you, Your Honor. This court has recognized that the inquiry in these cases is not whether the parent is a good one, let alone an ideal one. Rather, the inquiry is whether the parent is so bad as to place the child at serious risk of peril from abuse, neglect, or other activity harmful to the child. The trial court here erred by finding, by clear and convincing evidence, that Mother was unfit to provide minimally acceptable care for her child. Mother was able to provide minimally acceptable care for her child. The child had sufficient food, clothing, and shelter in her mother's care. Mother ensured the child had physical examinations with urgent care. The child was enrolled in school.
In her mother's care or in her sister's care? I mean, you got to grapple with how much of the parenting was done by the sister.
There may have been assistance within the family, Your Honor, with the child older sibling who resided in the shelter placement with Mother. That is correct.
So how do we deal with the fact that sister and mother aren't together anymore?
Well, Mother is still the caregiver. She was the primary caregiver and responsible for the child, although her older child was at times a substitute caregiver. Mother was capable of providing that minimally acceptable care, and the older sibling, when needed, was called upon and provided substitute care. Without going off the record, from the record that we know, at trial, the sibling was still a part of the family. The department was continuing to look at her for a guardianship and trying to assist her with housing for that. So we may be able to infer that the older sibling would still be able to provide substitute care in the event that the child returned to mother's care, if that was required.
Counsel, do you agree that all of the judge's findings of fact are supported by the evidence?
Not all of them, Your Honor. The 17 findings that I challenge as clearly erroneous, I would say the evidence doesn't support those specific findings, but outside of those that I challenged, yes. The child was enrolled in school in the 2021 to 2022 school year and missed 19 out of about 180 days of school. And the 2022 to 2023 2023 school year missed about 26 out of roughly 120 days. Of import, the school never filed a Section 51A report or a child requiring assistance application. Mother provided her child with emotional support during parent-child visits and encouraged her to have positive interactions with her placement resource when she was struggling. Mother displayed her instincts to protect her child during parent-child visits when holding her hand to cross the street and staying nearby in the swimming pool. DCF also confirmed that Mother's home was safe, clean, and free of hazards. In adoption of Nicole, this court said, the central judgment does not concern the parent's merits or demerits, but whether in all the circumstances, including consideration of those merits or demerits, he or she has the capacity to act as a fit parent. To uphold a finding of unfitness, there must be a linkage between the parent's mental health or substance use and abuse or neglect of the child.
So, counsel, the mother in March of 2023 had to go to the hospital because of a seizure, which the doctors indicated and the judge found was alcohol-related. Then she became unavailable to care for the child. Isn't that something that weighs against what you just argued, that she could take care of the child?
No, because at that time, the older sibling stepped in as that substitute caregiver, and that was in March 2023. The petition that DCF filed wasn't filed until May 2023.
But that gets to the problem I have. Now that the sister isn't with the mother, what are we going to do when the mother has a seizure again?
Well, I mean, it would cause me to speculate, but perhaps, there are other
I mean, but if you're a judge and you have a situation that works when the sister is there, but you can't see how it will work without the sister, then how can you find current fitness? Whether it gets determination or not, how could you do that?
Well, the trial judge didn't make that finding. Perhaps if that was a finding by the trial judge, we'd be in a different place here on appeal. But the trial judge made no finding as to the capability of the older sibling or whether mother's plan would be to call upon that sister. There were no findings with that regard. We know that the department was continuing to look at the sibling as a guardian in her own right. So we can infer that she was still having an ongoing relationship with the child and may be able to support mother. But mother on her own also was able to provide that minimally acceptable care. There are medical emergencies, seizures happen, and we wouldn't be in a good position if we were taking everybody's children away for having medical conditions or, unknown seizures when they're,
Well, most people with recurring medical problems that would make them unavailable make arrangements for their child to be cared for when that happens. But I didn't see any evidence of that here or any kind of planning for that here. Did I miss it?
There are no findings with respect to mother's plan should she suffer a medical emergency. But because I would argue that mother was able to provide minimally acceptable care, she would be able to nominate a substitute caregiver, maybe through a caregiver affidavit that would allow another person to make medical and educational decisions for her child. And the department and the court should allow mother that opportunity to nominate somebody should she become unavailable. As a fit parent, she should have the ability to do so.
When we talk about medical problems, usually a caregiver, mother or father, tries to take care of those medical issues. In this situation, the judge concluded, based on the evidence, that the mother was failing to address her alcohol and substance use disorders, which could very much lead to future medical problems. So if she's not taking care of her medical problems, i.e. alcohol use disorder and substance use disorder, why isn't that a finding that supports that she's not capable of the well-being of the child?
Well, there has to be a link between the substance use disorder and neglect to the child. Mother did suffer seizures, three seizures in a 17-month period, or sorry, 7-month period. that rendered her unavailable. There was no evidence after that point, and the judge made no findings that she suffered any further seizures. The mother's medical records were subpoenaed and entered.
But it's fair to say in a lot of these cases, a judge, you said predicting the future. Well, based on the past conduct, the judge can take into consideration what's going to happen in the future. So even though there hadn't been a seizure in, I'll call it recent based on what you just said, it's very likely there could be others based on the alcohol use disorder, right?
Well, we don't know that. I mean,
Well, we never know that. We're always trying to predict the future based on the past as to whether she can care for the child. So the judge made a connection between her medical problems, which were related to the alcohol, and her inability to care for the child. What's wrong with that?
the more recent evidence of mother cooperating with the department, and she was engaged with clean slate throughout the case, should be an indication that she's willing to treat those conditions.
Counsel, from November of 2019 to August of 2023, she only went once or twice a month to substance use treatment.
That's true, Your Honor.
How is she?
But trial wasn't until 2024, and at that time, she had that disability meeting with the department where they discussed how to service her, and since that time, mother was making improvements, and the trial judge should have weighed that more recent evidence of improvements against the past pattern or the past predictors.
But you would agree that the judge did consider that, did consider recent improvement, and
The
acknowledge
judge
that.
did make some findings as to her engagement with the department, yes. The trial court lacked clear and convincing evidence to support its conclusion that mother would be indefinitely unfit to provide minimally acceptable care for her child. As we discussed, the more recent evidence was that DCF held this meeting to discuss accommodating mother's disabilities, and since that time, mother's interactions and cooperation with the department improved. Although mother initially did struggle with her cordiality with the agency that removed her child, and she defied DCF's expectations of her, this court has recognized that a finding of unfitness may not be based on inappropriate factors such as disapproval of parents' lifestyle or a comparison of material opportunities a foster parent may offer with those afforded by a natural parent. As all parties correctly point out in their respective briefs, DCF's plan for the child was adoption by the child's then placement resource, with whom she resided 2 months by the time of trial. Although the plan need not be in writing, DCF did not provide it in writing.
Well, I thought the plan was less formed than that it was either that or go to the sister or maybe find a different adoption resource. Am I missing something? That's where I read the testimony, that DCF kind of had 3 options that were still in their heads.
Yes, Your Honor, that's correct. So the department's plan they were putting forward was adoption with the child's then resource, which she had lived with 2 months. Under Chapter 210, Section 5A, you can't file a petition for adoption for a child under 14 years old without the child residing in that home for 6 months. So the department's plan was to undergo the licensing study once the child had been there 6 months. She had not at the time of trial. There was also testimony provided that they were still seeking guardianship with the older sibling and trying to assist her with housing in order to do so. They also indicated that adoption with the older sibling was a potential possibility, and a last resort of recruitment with an unspecified home, unspecified characteristics of this family that they would be recruiting for if they had to. And therefore, I would argue that the department the trial court prematurely terminated mother's parental rights where DCF's plan was not sufficiently fully developed. As DCF noted in its brief, the adoption worker, I apologize, we just discussed that. I'll move forward. The improvement, the recent improvement that mother exhibited with the department, combined with DCF's insufficiently developed plan for the child, made the extreme step of terminating mother's parental rights unwarranted. Therefore, mother respectfully requests that this court vacate the decree terminating her parental rights and remand the matter for further hearing before the trial court, including for orders for post-termination and post-adoption visitation between her and her child. If the panel has no further questions, mother rests on her brief.
One moment, I'll check with the panel. The panel has no further questions. Thank you for your argument.
Thank you, Your Honor.
May it please the Court, Claire Gilchrist for the Department of Children and Families. We are asking you to affirm the orders of the lower court. The trial court correctly concluded, based on ample evidence, that mother's substance use disorder and alcohol use disorder greatly compromised her ability to care for child and meet her needs. This, combined with mother's untreated mental health issues and her behavior towards the child during visits, where she criticized the child and exhibited indifference towards the child's feelings, rendered mother unfit to parent the child. This unfitness, the judge correctly concluded, would continue into the indefinite future, based on mother's pattern of behavior and her lack of progress in addressing her parental deficits.
Counsel, let me put some of my cards on the table. What's concerning me is we have this sort of unestablished plan. And certainly if it winds up being adoption by the foster parents, then I can see why you need to terminate. But if it's going to be guardianship by the sister, it wasn't clear to me why termination is in the child's best interest, accepting the unfitness, the indefinite unfitness of the mother. But if that's still on the table, how do we know that termination is in the best interests of the child?
Your Honor, there can still be a cause for termination even if the plan is going to be guardianship. However, here the plan was not guardianship. The plan was adoption. The adoption social worker testified that the plan for the child was adoption by her current foster parents. Looking at the sister or recruitment were contingencies.
The sister is an option if she can get housing for both her and child. So it seemed like from the testimony of the social worker, that was still something that was being considered by the department.
That was one of two contingencies that the department had if the primary plan, which was adoption by the current foster parents, for some reason was not able to go through.
Well, why is that a better plan than the kinship sister guardianship?
Well, the plan with the sister would delay permanency further for the child because the department had studied the sister and she, I believe it was over the course of a year, had not remedied the central issue that the department had with that plan, which was her housing situation. So she'd had over a year to do that. That hadn't remedied that. So that was a plan that would have further delayed permanency. Whereas here, the child was in a foster home that she was very comfortable in. The evidence was that it was a good fit for her, that her needs were being met. And so that was more of a sure plan than the sister. Your Honors, as far as the post-adoption and post-termination visits, that was something that was entirely within the discretion of the juvenile court. She did have reasons here for not ordering them, which were mother's behavior during visits, which caused the child at times to seek comfort from the social worker. And it was clear that mother's behavior towards the child was dysregulated, and mother was unable to have consistently appropriate visits.
Counsel, do you agree that the inclusion of alcohol as a possible basis for causing psychosis was error by the judge?
I agree that, yes, that mixing of alcohol with amphetamines and Suboxone is not what the treatment records reflect could cause psychosis. However, that error, if it, that error would be harmless because the concern of the judge was that mother knew that mixing certain substances could lead to psychosis, and she was taking those substances that could cause it.
Mm-hmm.
If there are no further questions, Your Honor, I rest on my brief.
Just one moment, I'll check with the panel. And I see no further questions. Thank you.
Good morning, Your Honors, and may it please the Court, Noor Kazmi on behalf of the child. I wanted to address a question by Justice Ditkoff regarding why the termination of parental rights is necessary, regardless of whether guardianship or adoption is the goal for the child.
Yes, I'd very much like to hear that.
Thank you. So the standard for the termination of parental rights is it in the best interest to legally sever the legal relationship between the parent and the child. And the reason why it's in the child's best interest is just for that reason. If we do not affirm the termination decree, mother has an opportunity to continue to come back into court and rehash litigation regarding custody of the child. And as we can see from the record, mother has an 11-year history of substance use and untreated mental health. The idea that we leave open mother's ability to reignite custody is not in the child's best interest. Nothing in the record had indicated that mother acknowledged her parental deficiencies or that she sought treatment to improve and made improvements to her parental deficiencies. So if we leave open the issue of litigation, then the child's status, her permanency, is in jeopardy, and that can create, and that I would argue is against the child's best interest. So regardless of what goal the department moves forward with, termination of mother's parental rights is in the child's best interest. And just to touch more upon the visitation aspect, I don't believe that the trial court erred in declining to order post-visitation contact simply because the quality and consistency of the visits, as we've seen in the record, is poor and inconsistent. Mother called the child a moron and a retard. Yes.
Do you think we have enough findings? Like, it was hard to figure out what the judge's reasoning was on the visitation. I could certainly see why one could find visitation didn't make sense, but do we have enough reasoning to review?
Yes, I do believe we do, because for the first 6 months of the child's removal, mother refused to see the child. 6 months had gone by after the child was removed from her care. Mother was in contact with the department, but refused to see the child. Towards the end of the, as we approached the trial date, mother, again, was inconsistent with her visits, and there was repeated indications that mother made comments and engaged in erratic behavior that made the child uncomfortable. Finally, the last visit before trial, mother took the child's glasses and didn't give them back. It's bizarre behavior, and there was record to indicate that these visits made the child uncomfortable, and the judge had enough to determine that it was not in the best interest to order post-termination and post-adoption contact. And just to highlight, the record did reflect that the child had made some substantial improvements while in the department's care, including no longer missing school. When she was with the mother, she was held back, and then she continued to miss school in the first grade. When she came into care, she no longer missed school. She was up to date, and even though she had an ADHD diagnosis, she did not need an IEP, and that the pre-adoptive home, the potential pre-adoptive home, was able to meet all of the child's needs, and she was able to thrive in that placement. And if there's nothing further, no questions, Your Honor. Thank you.
Thank you very much. So thank you all for your arguments. We'll take the case under advisement. We are familiar with the fact that these cases are always very difficult, and you can be assured that we'll look at the entire record very carefully before we